In this program, we will focus on private company transactions. In short, someone comes to you with a transaction, and we assume that we are acting for the investor in a corporate finance context or the purchaser in a mergers and acquisitions context. Note that we won't be dealing with prospectus transactions and other going public type transactions. Let's go back to the definition. Assiduity. What does it mean? Constant or close application or effort, diligence, and industry. Let's now consider due diligence as a preventative measure under environmental legislation. In Wholesale Travel Group, which is a 1991 decision of the Supreme Court of Canada, the court addressed the concept of reasonable care, holding that adequate due diligence on the part of a defendant is case-specific, and that the standard of care will depend on the facts and on the particular industry. In the environmental context, for example, the court found that a high standard of awareness and decisive, prompt, and continuing action is required, not superhuman efforts. The court also found that consideration is given to the nature and gravity of the adverse effect and the foreseeability of the effect. Some efforts that a court will consider in a due diligence context include, was there supervision or inspection, in this case, of the pollution prevention system? Did each director ensure that the corporate officers were instructed to set up a system sufficient within the terms and practice of the industry to ensure compliance with environmental laws? And can directors substantiate that officers are promptly addressing environmental concerns brought to their attention by governmental agencies or other concerned parties, including shareholders? In other words, context is everything in due diligence. We should note that there's no absolute standard for due diligence. It depends on the facts of each situation, what a reasonable and prudent person would do in the circumstances, as the definition tells us. As an example, the Ontario Business Corporations Act provides that a corporation's director is not liable under Section 130, which relates to shares issued for consideration that is less than cash value, and has complied with his duties under Section 134 sub 2, which is the directors exercise the care, diligence, and skill that a reasonably prudent person would have exercised in comparable circumstances.